In Norway, it's actually a two-tier system. Out of court, you have the family counseling offices, which are always available for parents who have conflicts regarding their children, regardless of civil status, whether they're married or not, or divorcing. And they also do mandatory mediation, but just 1 hour when parents split up and they have children under the age of 16. And if they want to go to court in these cases. Of course, we have a court system for these cases, but they are handled in the district courts, which are courts of general jurisdiction that handle all types of cases, both criminal and civil, but with some special rules being applied in these cases. Particularly during the preparatory stages, there is sort of a judicial mediation scheme or settlement scheme where the judge would try to mediate between the parents, and he would often have a psychologist to help him with this. And the psychologist also can have other roles, can talk to the parents separately and the child, maybe do some observations in the home, and also the parties may reach an interim settlement, which means that they can try out an arrangement for contact and custody for a couple of months. And then the expert would act as a sort of a sounding board for the parents and might also do some observations during that period. If the parents are able to settle either after the first attempt or second or third attempt, there could be a final settlement. Otherwise, the case would go to the main hearing. And also in that case, they would use very often an expert, a court-appointed expert, which typically would be a psychologist who would make an assessment which would serve as evidence in the case. And this carries quite a bit of weight. You can sum up the shortcomings in the phrase, either get counseling, agree, or sue. That is what you can do on the Norwegian system. Out of court, the state offers counseling and mediation. Otherwise, you have to go to court. And this is a problem because, of course, going to court is very expensive. And when you split up, you don't particularly want to spend your stretched financial means on going to court. And also, of course, we know of the strain of both on the parents and on the children in that kind of scenario. It escalates conflict and so forth. What I think is the shortcoming is that you don't really have any form of public interference or help other than counseling and mediation out of court. So if a parent feels insecure about, well, is it safe that the father has the child for an entire weekend? What should I do? There is no door you can go and knock on and get a psychologist who gives an assessment as part of this out-of-court dispute resolution process. Then you have to do it privately, which costs money, and which is also seen as less credible when it's paid for by one of the parents in a subsequent court case, if there should be one. If a parent says, well, you're not getting any contact with this child, I'm stopping it, the child doesn't want it, or you're detrimental to the child, there is no way of getting a temporary decision on contact unless you go to court. And then you have to do the whole thing, going to court and file for a permanent change in the arrangement. Either you have such a low income that you can have legal aid, and then it's perhaps okay if you take away the very important dimension of the conflict aspect of it, or you have moderate financial means, and you may not afford to go to court. And so you're stuck with the choice of accepting something that you find unreasonable or risking invoking costs that you may not be able to carry or which may not be wise to carry, and also escalating the conflict. The problem is really that a parent can choose to disregard even a judgment and nothing, and the other parent can be in a situation where nothing can be done. Realistically, we have a system that you can have a judgment or a settlement, which is a judicial settlement, enforced by giving a fine, which would be the most normal way of doing that. But it's very uncommonly used, and the ministry says it's not really effective. because of that. And having the child forcefully been fetched from the home, that is, fortunately, I have to say, very rarely used. And these are the means that we do have. And so there are some holes here in the system if you're a parent who have an unreasonable co-parent. A new mediation proceeding, or I would rather say a system of judicial settlement efforts, was introduced in 2004 in all district courts in Norway, following a pilot which was done in a few courts. And the rationale was that some parents who come to court, or many parents who come to court, they haven't been able to agree at the family counseling offices, but there still might be a potential here to reach agreement if they get the right help. And so they introduced a system where, as part of the preparatory stages of the trial, the judge would mediate and very often have the aid of a psychologist who will have different roles. He be the co-mediator, and he can also give some advice to the judge. He can give general information about what children different ages will need, what is important to think about. He can hear the child, he can talk to the parents, do some investigations, observe contact. And the parents may agree on an interim settlement. It might not be feasible at all to reach a final settlement. The parent might just say, no, of course not, we don't want to settle this case, now we're at court. But then it might be much easier to accept an interim settlement, say, okay, we might as well try this then for 2 months, but I assure you this is not a good way of doing it. And this has proven quite effective in many cases. I cannot say anything about how constant these settlements have been, because it hasn't been researched, but at least the findings have been that there are many settlements, and many lawyers report back that they're quite happy with this system. And so this is seen as a core element of this mediation scheme. They negotiate a temporary agreement between them, and typically with the duration of a couple of months. It can be longer, and then have a set date where they reconvene at the court again. And in between, in that period of time, there would typically be an expert appointed, typically the same expert that mediates and aids a judge. That could be a sounding board for the parents, helping them to talk through difficulties that they face, worries that they might have. Child protection services generally shy away from these cases. If they hear it's a matter of a conflict between two spouses, they say, well, you have to solve this either at the family counseling offices or you have to go to court. We don't intervene in conflicts between parents. This is not our mandate, they say, typically. There are exceptions, but this is sort of the main view. And what is the problem with that is that they don't really investigate if it's really, really cause for worry that the parent keeps the child away from the other and says very unfavorable things about the other parent. Typically, they won't even talk to the child in these cases, so they shy away from those cases. There are several reforms on the way. Some has come as far as being proposed now by the ministry after law reform committees have suggested them. So these are quite feasible, that will happen. There was one reform that the ministry said, no, we're not going to do this. And there was a law reform committee that suggested that there should be 6 hours of mandatory mediation at the family counseling offices to keep the cases away from court, and then they should more or less abolish the system which I described earlier about preparatory meetings and mediation and interim settlements. But then the ministry said, well, this proposal lacks empirical support because we used to have 3 hours of mandatory mediation. We reduced it to 1, and there was no decrease in the number of agreements being reached. And so what the ministry has taken from the proposals that have been coming instead is that they want to do something about the voice of the child in the out-of-court mediation. There's been a proposal that the child should always be heard by the mediator. The traditional view in Norway has been that as long as there is no court or administrative body making a decision, it's up to the parents to hear the child. And you can imagine that can be very conflict escalating and problematic. This is new, and I think it will be enacted that the child has a right to be heard by the mediator, regardless of what the parents think about it. And if the child is being heard, and if there is an imminent court case, then what the child has said, its statement, will then be sent to court. It goes along with the case, so ensuring that what the child has said is actually being taken into account. There's also been a proposal which has not come as far yet. The ministry hasn't concluded on it. And that's a matter of letting children initiate mediation and counselling at the family counselling offices. Another proposal, which was actually the ministry's own proposal, which I think is very good, is that there should be an option if a parent keeps a child away from the other for whatever reasons, or there is a substantial reduction in the contact that the other parent gets from what they have agreed on. That parent can go to court and say, I want a temporary decision on contact. Just a temporary decision. I don't want a full court case, I just want a temporary decision on this. And then the court, as a main rule, has to do that within 4 weeks. When you talk about the voice of the child, of course, it must always be interpreted what the child says in relation to the other facts of the case and what goes on between parents and so on. So when I say that there is a reform to have the opinion of the child or whatever statements the child has given forwarded to court, it would not be an abracadabra and then that would be the end of it. As always, you have to interpret what the child has said, and it has to be weighed according to the child's maturity and age, and also there has to be evidence about other factors, for instance, whether there has been manipulation of the child or the child feels a very strong loyalty to one parent. And these are the kind of questions that typically a court-appointed expert would be tasked with. What I would wish for, I think it's a good step that they are now saying that the child should have an independent right to be heard by the mediator family counselling officers, so that becomes the absolute main rule. I think it's a good thing that the courts will have, of course if enacted by Parliament, the option of, or the duty to render a temporary decision on contact if a child is being withheld from the other parent. But what I would wish for was more of a multi-door system at the family counselling offices. You would have the family counsellors who are excellent at mediating and providing counselling, but then you could have, down the hall, you could have a lawyer who could render temporary decisions on contacts and also perhaps give some legal information to the parents. You could also have experts paid by the state, the same as the state pays for the experts in the courts as well, so they might as well pay for them at the family counselling offices. And then the difficult parent who says all sorts of things about the other parent, about their lack of parenting skills or the unwillingness of the child, would have to sort of meet the results of an assessment by that psychologist. So that might take away some of the unreasonable claims. And also, the worried parent who is actually worried might get some reassurance. They have some elements of that in Denmark, which I think is quite good, that they have other services available than just the counselling and the mediation, which is, of course, very important, but it cannot stand alone.